A newborn is back with his biological parents tonight at a hospital in North Texas, but still caught in a surrogacy battle spanning multiple states. It's a complex case given that the baby was born in Texas and a court-ordered life-saving heart surgery. Adriana D'Alba is in our newsroom to walk us through what's at stake here.
And Chris, this case raises a major legal question. When a surrogate agreement crosses state lines, which state's laws take control? Legal experts say this case is rare, and it's also testing what happens when surrogacy agreements fall apart.
This is McKenna West, a surrogate at the center of a high-profile surrogacy fight unfolding in North Texas.
I really didn't know what to do.
In an interview with the anti-abortion organization Live Action, publicly posted on YouTube, West described her reaction after doctors diagnosed the baby she was carrying with a serious heart condition about 20 weeks into the pregnancy. She says the child's parents tried to force her to terminate the pregnancy, something the parents deny.
It was just a horrible, trapped feeling to be like, this is my body and I absolutely don't want to go through this. But I just felt like I didn't have a say.
The legal fight has now spread across 3 states. It started in California, where the intended parents live. Then came the baby's heart diagnosis and the request to end the pregnancy. West, who lives in Alaska, refused and came to Texas for legal protection, giving birth yesterday. Attorney General Ken Paxton secured an emergency order to keep the child in Texas for treatment. And now the courts are left to sort out which state's laws apply.
The situation is more rare because of how far the conflict got.
The surrogate now wants custody, but a Texas court has already ruled that the child's biological parents are recognized as the parents. ABC News legal contributor James Sample says the laws in Texas and California could point to different people having decision-making authority.
The actual mother who gave birth under Texas law would be the one to make these decisions. Under California law, it's the intended parents.
And he says under a full faith and credit clause, the rulings in California before the child's birth go first.
But the question becomes whether Texas honors a pre-birth ruling of a sister state.
What's not in question right now is that the intended parents are the legal parents who are entitled to the custody, care, and control of the child.
The intended parents, attorney Lee Budner, says in a statement, as if the heartbreak of this condition were not enough, they are devastated to see their family tragedy transformed into political theater by the Texas Attorney General's office and McKenna West. For now, the baby remains in a North Texas hospital.
And this legal battle is just beginning. There's a court hearing on the case on August 25th, and we will follow up on the story. Live in the newsroom, I'm Adriana D'Alba.